Justice Srikrishna, data protection law would have held government to account. Hello and welcome to Inventiva. This is Palak Yadav presenting to today's big news. The government would have been as answerable as any private entity for the alleged breach of privacy for individuals by Israeli company NSO Group's Pegasus spyware had there been a data privacy law in place in India, former Supreme Court Judge Justice B N Srikrishna told the news. The data protection law would have allowed those who have had their phones targeted by the surveillance malware to seek legal redressal, he said. The law that was proposed applied to private companies as well as the government. A government department would be answerable if there was a data breach. The only way the government can access the data is by bringing a parliamentary legislation which empowers them to access data under certain circumstances. Justice Srikrishna, who headed the government's committee that drafted the original personal data protection bill, said. Earlier this week, a global collaboration of 17 media outlets, including The Wire from India, started publishing reports that said some 50,000 telephone numbers could have been targeted for surveillance by government clients of the NSO Group. The leaked global database was accessed by French non-profit Forbidden Stories and global human rights organization Amnesty International and shared with the other media partners. The Indian list of 300 verified numbers includes those used by ministers, opposition leaders, journalists, the legal community, businessmen, government officials, scientists, rights activists, and others, The Wire said. The Guardian, however, cautioned that the presence of a phone number in the database was not by itself confirmation of whether the corresponding device was infected with Pegasus or was subjected to an attempted hack. Justice Srikrishna said with a concrete data protection law would have allowed people whose names have surfaced in the Pegasus project reports to take the government to court for breach of privacy. They could do so even now. If the law would have been there, they could have sued the government because this snooping is only what the government can do and nobody else. It's possible even now. Anybody can move the Supreme Court under Article 32 and say that fundamental rights have been breached now as privacy is a fundamental right under Article 21. At least the issue will be public then, he said. A 9-judge bench of the Supreme Court recognized privacy as a fundamental right in a unanimous ruling in the landmark Justice K.S. Puttaswamy versus Union of India case in 2017. The allegations regarding government surveillance on specific people has no concrete basis or truth associated with it whatsoever.